So we have a written motion for directed verdict on behalf of Mr. Kendrick. Is there a separate one for Mr. Stillwell or you? Okay. All right, Mr. Kendrick, you want to present yours? I haven't had a chance to read it, only see that it got.
It was last minute, Your Honor, so.
No problem.
Good morning, Your Honor.
Good morning.
Let me begin just by stating that Mr. Shart and I last night went through a number of the predicate acts and overt acts that are in the indictment, and we've kind of made a detailed list of those predicate acts that we do not believe have been presented at trial.
Okay.
And I'm going to let Mr. Shart speak to that when he makes his motion orally this morning. I join in all of those that he does. And we are moving for a directed verdict on each of the counts against Mr. Kendrick, counts 1, 2, 50, and 57 through 63. And I'll go through each of those in order.
All right.
We're also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment. Based on where we're looking at the jury instructions and the law, my understanding is that the jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision. As to, just turning to the details of the different counts, as to count 1, Your Honor, the RICO count, in that situation, in that count, I don't believe the state has shown evidence upon which a rational trier of fact could find an overarching conspiracy seeking to achieve an overall common goal as required by the law. The state has shown a number, quite a few, I would agree, a number of individual acts they've presented. They have presented a number of crimes and alleged crimes committed by co-conspirators. But I do not believe that they have presented to this jury any form of an overarching conspiracy that would tie those acts together. The second part, I don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature. So I'm not going to spend a lot of time on that. I don't want to take up the court's time. I have some things in my written motion. Third, a pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other. And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury. and that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they've stated, I would say universally, I mean, it's been a year, so I don't know that I have everything in my head, but I believe they've stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they've presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although, again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas. Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffrey Williams' house on May 9th, 2022. Each of those counts is either specifically gun or a gun count or a drug count, or they're predicated on a gun count or a drug count. There has been zero evidence of Mr. Kendrick in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession. And I'm assuming they're going to argue this because they have two pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. So, but let's assume he's inside the house, even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. Zero on intent and zero on his ability to access those weapons and drugs. Last, Your Honor, with respect to count 63 is the 133 charge against Mr. Kendrick. As we discussed previously in court, there is an essential element of 133 that has been left out. So I believe a directed verdict on 133 would be, on that count would be appropriate.
Let me interject and ask you, I saw that Mr. Abadi had sent something that addressed whether, even if directed verdict is appropriate on that, a lesser included. Can you address that?
Sure. I saw the one specific case that I saw that would support Mr. Abadi's position was Martinez v. State, 318 Georgia Appeals 254. And that case, from the limited time I had to review it and do further research, does appear to support Mr. Abadi's position regarding 131 being chargeable. But that case, I cannot find a single other case that follows that case. I also, just again to be candid with the court, I don't see any case that says that case is wrong. But I would argue that the 131 count should not be charged to the jury, if for no other reason than the state puts that 133 charge. Well, I don't know what the state's motives are, but I would argue that the motives of charging 133 versus 131 is that 133 carries significantly higher penalties, and that they put in 133 in order to have greater leverage in plea negotiations. And I don't think, after having used that leverage for the past 2 years, that they should now that they can't prove up the 133, should be allowed to reduce it to the 131. But I cannot argue right now before you that Martinez does not support the state's position, Your Honor. And then again, I'm going to adopt whatever arguments that Mr. Shart is about to make on behalf of his client that would also apply to Mr. Kendrick.
Okay. So, Mr. Shart, I mean, I guess there's overlap on counts 1 and 2 for these two defendants, but those are the only counts that overlap, right? Yes.
Yeah, I believe that's
Okay.
right.
All right.
Do you have any further questions for me, Your Honor?
No, not right now. Thank you, Mr.
All right, thank you, Your Honor. I'd be happy to answer any other questions you have.
Appreciate it.
Good morning, Your Honor.
Morning.
Okay. So, I have arguments regarding several different counts in this indictment, as well as some of the overt acts, which I believe also need to be addressed, the alleged overt acts. And there's different arguments for different counts and alleged overt acts. I'm going to start with dealing with the this argument applies to the RICO count.
Can I ask you something
Yep.
before you get
Yes.
started that might assist me? I think Mr. Weinstein said you might have a chart. Do you have something that's shareable with the court, or
I
is
don't. I don't. A chart is overstating what it is.
Okay.
We went through. We were trying to determine what specific counts, what
Okay.
evidence has been provided to the jurors so far in this trial.
Okay.
So let me just give a little background. I'm going to ask the court to consider Ruan v. United States, RUAN v. United States, 142 Supreme Court 2370 to 2022 case. That case explained that the commonly understood rule that as a general matter, our criminal law seeks to punish vicious will. Consequently, when courts interpret criminal statutes, courts start with the long-standing presumption traceable to common law that the legislature intended to require the criminally accused possess a culpable mind state. Applying the presumption of scienter, courts have been legally mandated to graft the material elements of mens rea into criminal statutes that are silent on the required mind state. Okay, and to bring it to this situation, the RICO statute is silent as to mens rea for the accused, as is, well, and not so much mens rea. Well, it is mens rea, but there's also an aspect of this that will apply to the gang statute as well. In United States v. Resendez-Ponce, 549 U.S. 102, it's a 2007 case, the United States Supreme Court wrote that the elementary legal principle is that every count of an indictment must set forth all material elements of the crime charged in order to be valid. In Division 2B of Elonis, E-L-O-N-I-S v. United States, 575 U.S. 723, it's a 2015 case, our highest court again taught that the fact that if a statute does not specify any required mental state, it does not mean that none exists. The Elonis court explained that courts have repeatedly held that the mere omission from a criminal statute of any mental or criminal intent should not be read as to dispense with this essential element. The rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. In other words, just because there's no mens rea listed in the criminal statute does not make it a strict liability crime. Okay, going to the indictment in this case. Count 1, RICO. Mr. Stillwell and Mr. Kendrick, to be guilty of count 1, the jury under the law would have to find that Mr. Kendrick and or Mr. Stillwell joined the conspiracy knowingly and willingly. The state, I'm going to ask Your Honor to consider the Cotman case, C-O-T-M-A-N v. State, 342 Georgia Appeals 569. It was a conspiracy to commit RICO case. That indictment alleged knowingly and willingly. My understanding, I have not seen the indictment, but I've been told the Trump indictment also includes knowingly and willingly. In this case, the state has not alleged, and the grand jury did not return a indictment, a true bill, alleging knowingly and willingly. The indictment for count 1 is missing an essential element that has been required by the case law. Although OCGA 1614-4 fails to include knowingly and willful mens rea requirement as discussed above, when the statute is silent on mens rea, courts define the proper mens rea requirement to avoid it becoming a strict liability crime. I will point the case to Wetzel, or I think it's Weitzel, v. State 298 Georgia 20, that discusses the concept of just putting unlawful. Does unlawful, as the state did here, does that cover knowingly and willingly? Is that an effective substitute? Our position is it is not. We believe that the Weitzel case supports that. So, Your Honor, we believe that the RICO count 1, is missing an essential element that has not been required by statute, but is required by the case law. And because that knowingly and willfully requirement, that mens rea requirement, is missing from the indictment, count 1 is subject to a directed verdict, a general demur and directed verdict, as it applies to both Mr. Stillwell and Mr. Kendrick. Now, turning to the gang counts, and I can get you the specific counts when I have a moment to look at the indictment. But going to the gang counts, the requirement, again, the gang statute under the Georgia Code is absent as to an essential element of the crime, which is in furtherance of the gang. That statute was in constitutional jeopardy before the Rodriguez case. The Rodriguez case saved the statute by adding an essential element to the gang statute, which is not only someone associated with the gang committing one of the specified crimes under the Gang Act, and the existence of a gang of 3 or more people, but additionally, Your Honor, they added, to save the statute constitutionally, the Rodriguez court added the requirement that the alleged illegal act must be in furtherance of the gang. The indictment in this case for all of the Gang Act violations, all the alleged Gang Act violations, none of those alleged Gang Act violations on this indictment returned by the grand jury allege that the act committed was in furtherance of the gang. Now, we know that that must be proven. The jury charges that we're going to give the jury list in furtherance of the gang as an essential element of this crime. And it is absent in all of the Gang Act violations alleged in this indictment, as the indictment for those counts does not allege every essential element of the crime. Those counts are subject to a general demur and a directed verdict as well. So that's one aspect of my arguments. I can move on to my other arguments, or I can put a pin
Give
in
me
it.
just a second.
And Mr. Abate just gave me, just helped me out, and I appreciate that, Mr. Abate. I'm referring to count 57 for Mr.
50,
Kendrick, and
51,
50 and 51.
57.
Yeah.
Thank you.
Okay, go ahead.
So, moving on to the overacts, and I adopt Mr. Weinstein's arguments regarding count 2 as well. Moving on to the alleged
Well,
overacts.
Can you actually, I mean, you can adopt those, but do you have anything to add with regard to count 2? Because Mr. Weinstein was basically talking about, the evidence or lack of evidence as to his client specifically.
The only evidence against Mr. Stillwell, there's no cell phone evidence. There's nothing of that nature. There's no identifications from the scene. The only evidence are social media posts and the testimony of, well, not the testimony, the out-of-court statements by 2 individuals, one being Quindarius Zachary, who completely disowned what he said, and back in the interviews when he was under the pressure of incarceration, under the pressure of prosecution, and we pointed out, hopefully effectively, that Mr. Zachary's story about this confession changed in material ways from when he told the story in 2015 to when he told the story in 2017. When this confession allegedly occurred changed, what was said allegedly changed, the circumstances changed, and then Mr. Copeland, I mean, you were here for that. He made out-of-court statements under the pressure of incarceration. He's openly admitted he would have said anything to get out of jail, to avoid prosecution, to avoid Rice Street, and his statements were not even that he witnessed anything, but he was told something by someone else who did not testify. So that is as far as I can tell, the entire university evidence against Mr. Stillwell, and our argument is that it doesn't clear that hurdle of surviving directed verdict.
All right.
So, moving on to the alleged overacts, and I'll point out in this indictment, it lists, this is a conspiracy to commit RICO. So they don't need to prove the predicate acts. They don't, those 2 related events within 4 years apart, they don't need to prove that, because all they need to prove is a conspiracy and 1 overact. So,
Well, a conspiracy to commit 2 interrelated racketeering acts in furtherance of the enterprise.
yes, okay, that is fair, but they don't have to prove that the
That they
acts
occurred.
actually occurred.
Agreed.
So on page 14 of their indictment, it starts part 3, acts in furtherance of a conspiracy. It says, in furtherance of the conspiracy and to effect its objectives and purposes, the defendants committed and caused to be committed, among others, the following overacts, certain of which constitute acts of racketeering activity. So this part 3, this isn't about, they identify some things as overacts. They identify everything as an overact, but they also identify certain things as falling as a predicate under 1614.3 for racketeering activity. The nature of this allegation is this conspiracy. So they don't have to prove that these predicates occurred. So essentially, my reading and my argument is that part 3 is essentially a list of overacts. That's what it is.
Yeah.
And we are all of the same opinion. We're giving the jurors a jury instruction. It's clear, it's in the statute that the statute of limitations for the overacts is 5 years before the date of indictment. And And that's going to be, my understanding, that's going to be charged to the jury. So I, as a general principle, I do not understand if they only need one overt act, okay? And that overt act has to be within 5 years of the date of indictment. All of these other alleged overt acts that can't count, can't be used, and are completely not needed. I could see a situation, for instance, if they needed to show 2 overt acts, and one had to be within 5 years of the indictment, but one didn't, okay? It was just the last one needed to be within 5 years, but they needed to show 2. I could see the need for all of these other allegations, but that's not the case. They need to prove 1, according to their arguments, and it has to be within 5 years of the indictment. So everything that predates that cutoff date, which I think would be May 10th of 2017, it can't be used to convict.
It's not sufficient.
Well, but it doesn't add anything either because you only need 1.
Well, they also have to prove a conspiracy and an enterprise, and so.
They do have to prove a conspiracy and enterprise, and I'm not arguing that they can't argue about these things in closing. I'm not, I never argued that they couldn't get into these things, but they shouldn't be alleged in the indictment going back to the jury because we're telling the jury, we're sending the jury a completely mixed message. We're saying you can't find an overt act that
We're not saying that. We're not saying you can't find an overt act before the 5 years. What I will be saying is it is necessary if you want to convict
right.
that you find, or if you believe there is evidence sufficient to convict, part of that evidence has to be an overt act within 5 years.
But by definition, no, I'm not, believe me, I'm going to fight tooth and nail about any duty to convict language, and I don't think there is any. But in layman's terms, if they find an overt act within 5 years, that is legally sufficient
Correct.
to authorize a conviction, which would make all of these other.
I hear what both of y'all are saying on that, and I just don't think I'm convinced that it should not even be presented to the jury because it's not sufficient in and of itself. But go ahead.
Okay, and
I mean, that's not exactly directed verdict issue anyway.
no, but I believe it is. I would say at this point, it is mere
Surplusage.
mere surplusage, I would say, and that it's going to confuse the jury to have this list of alleged overt acts where legally none of these prior to May 10, 2017 can be used to authorize a conviction on the overt acts, for the overt act element of the RICO conspiracy. So, and then additionally, Your Honor, in all candor, we stayed after court. We went through all the charged offenses in the indictment, all of the alleged overt acts in the indictment, and we did our best. We didn't have the evidence in front of us. We did our best over the night, over the evening and this morning to go through those, and we either said, we're not challenging it. We recall that there was evidence that would survive a directed verdict. We were unsure, or we're pretty certain there was no evidence of this.
Okay.
And so, but, you know, it's a long list. And probably, I would suggest, to your honor, for that part of this argument, it kind of be more of a back and forth as opposed to me just listing off a bunch of numbers. I can.
Well, I've got to know what you're alleging.
Okay.
Are you talking about, like, help me out, which overt acts you think there is no evidence presented for?
Yes.
Okay.
As well as predicate acts.
What's that?
As well as predicate acts.
Yeah, but there,
You have the list?
Have y'all talked to the state about this at all yet?
we haven't had an opportunity.
Does the state acknowledge that there are maybe at least some overt acts that no evidence was presented on?
Yes, Your Honor, and
Okay.
we don't intend to have that go back to the jury, and so we can discuss with defense
All right,
counsel
I
those
can
acts.
certainly let y'all do that, and if there's some that, I mean, I know there were at least a few that no evidence got presented on. So to the extent y'all can reach agreement, that would be fine, and then if we want to take it up later in the afternoon after y'all have gotten a chance to get together on it, that'll work.
Okay, thank you, Your Honor.
And there may be some y'all want to argue about, so we can do that later. So that's fine.
Okay.
Okay, and then do you want to argue specifically as to the other counts against Mr. Stillwell?
Well-
We've done kind of 1 and 2 at this point.
Right, I've argued the gang counts.
Oh, right, and yeah,
And I've argued the RICO. The Shamal Drinks alleged murder, I think the video speaks for itself. I don't believe that there's sufficient evidence that would authorize a rational juror to come back with a guilty verdict. You know, we heard from Dr. Stanley, the ME. She was clear. Mr. Abate asked if someone's foot could stay on the brake, and she acknowledged that a foot could come on the brake and stay on the brake after being shot in the neck. And I asked, what about lifting the foot off the brake and putting it back down? And she said that would be an impossibility. We see clear from the video that Mr. Stillwell was, I think, gone. I'd have to review my notes, but I'm going to say it was about 26 seconds, I believe, between when his car left and when that brake light on Mr. Drinks' car was going on and off. Additionally, we have the U-turn. Additionally, we have the negative gunshot residue test, that we have no muzzle flash. It seems to me that we would have a muzzle flash. If we don't have a muzzle flash, the logical conclusion would be the shot was fired from inside the car. We have a negative gunshot residue result. And we heard from Mr. Coven from GBI. He followed all the procedures. Although there's been speculation and, of course, the grave suspicion jury instruction that we all go by, we're not supposed to speculate. We're not supposed to use conjecture, I think is the word that they use. And there's just a lot of speculation. Well, what if this happened? What if he cleaned the car? And there's no evidence that supports any of those theories. So the Drinks murder, as well as the associated charges with the Drinks murder, which would include a gun charge and also a gang charge, I believe, would also be subject to a directed verdict. As it applies to the final gun charge of Mr. Stillwell's on the 17th, I'm not going to argue that there's not evidence that could survive a directed verdict. You know, we've heard it was the gun that was found on Meadowlark was registered to Taisha Alexander. We've heard Taisha Alexander is Mr. Stillwell's girlfriend at the time. But I will adopt Mr. Weinstein's arguments. This was indicted as 16-11-133. We were put on notice for 133. It's missing an essential element, and we're going to argue that the state should not be able to alter on the eve of closing arguments, alter the charges. And also, I'm not even sure about the mechanics of how that would happen at this point. It's charged under a certain statute in the indictment. I guess
Well, I
if it
think
were,
it would be just like we always do any kind of lesser included offense. I mean, that's their argument is, yeah, we may not have the elements, and they certainly don't have the elements for 133, but we have the elements for 131, and that's what should get charged instead.
okay, well, Your Honor, every time that I've dealt with lesser included, it's because there's some sort of, maybe not surprise, but the evidence didn't come across quite as we were expecting or the state was hoping, or the defense requests a lesser included. We're not requesting a lesser included, first of all, but they put us on notice to defend against 133, and they left out an essential element, and now we're changing the charges on the eve of closing arguments. So that's my argument regarding that.